Hello entrepreneurs, it's Michael Mort with Argent Place Law, the law firm for entrepreneurs. I want to talk to you about LLC and S-Corp, the differences, the advantages of one over the other. This is a question I get a lot. When people are starting out, they often come to me and say, hey, I've been told maybe I should be an S-Corp. What's the difference between an S-Corp and an LLC? Well, the truth is, you can be both an LLC and an S-Corp. I've given many talks on this kind of stuff. LLC refers to the type of governance for your company. It's something that's done by the state, not the federal government. You can file your company with the state, whether it's Virginia or Louisiana or any other state in the union. You can file as an LLC, register as an LLC, or you can register as a corporation. All right? But once you decide to be an LLC, and most lawyers are going to recommend this because it's highly flexible, the form of governance as well as its taxation. Once you start an LLC, you get to choose how you want to be taxed. The IRS just gave up and decided let the client choose, the owners choose how they want to be taxed. Your basic default way is to be taxed. If you're a single member LLC, it's a pass-through, it's a disregarded entity. The IRS treats it as if you were a sole proprietor. But if you have a partner, the default way is that it would be taxed as a partnership. The company would have to file a partnership tax returns. Everybody gets K-1s to show how much money the company made. But you can elect to be taxed in one of two forms of a corporation. Even though it's an LLC, you can be taxed as a corporation. Now you can choose to be taxed as a S-Corp or as a C-Corp. Most people would choose S-Corp. There are a bunch of disadvantages to C-Corp. I'm not going to get into that right now. So the basic choices between being taxed as a sole proprietor or partnership, depending on single member or multiple members, or being taxed as an S-Corp. Why would you choose S-Corp over a single member, over being taxed in one of the other ways, partnership or sole proprietorship? Well, in the default way, as a partnership, say, the owners cannot be employees. You do not get a W-2. All of the income of the company, all of the net profits of the company flow to the owners, and you report that on Schedule C if you're a sole proprietor, or Schedule E, I believe, if you're a partner, have a partnership. So all of the income flows to the partners in proportion to your ownership interests. I'll talk to you in a minute about the disadvantages of that, but the main thing is the percentage ownership thing being a problem. But the main thing is all of the income, even income that you leave in the company, gets taxed. And how? You have to pay. Partners and sole proprietors have to pay what's called self-employment tax, both sides of FICA, 15.5% to Social Security Administration on all the income, whether you take it out as distributions or not. So if the company, for example, has $100,000 in profits and you want to distribute $80,000 of that as in distributions to the owners, doesn't matter. You're still going to pay income tax on the whole amount, and you're going to pay FICA on that additional $20,000 that you leave in the company for future growth. That $20,000 is going to get taxed to the owners at 15.5%. That's $3,000 you're going to be leaving in. You're going to be paying out in FICA, even though you left the money in the company for future growth. But being taxed as an S-Corp, the money that you leave in the company, you get to pay yourself a salary, and of course you're going to pay FICA on the money that you pay yourself a salary. The employee, you're an employee of the company under S-Corp rules, you can be, and so you're going to pay, as an employee, you're going to have to pay your share of FICA, and the company is going to have to pay another share of FICA, a total of 15.5%, but you only pay that on the money that's distributed in W-2 income. You leave money in the company for future growth, say that same $20,000, that's only going to be subject to income tax, not to FICA. So you get an immediate tax savings of over $3,000. Okay, there's another reason. The second reason that's important to have allow yourself to be employee of the company is if you have different types of partners. For example, often you have a situation in which there will be one partner who's silent, doesn't do anything, doesn't do any operations in the company, contributes no services. Only it might be a money partner, friend that has some money that wants to invest in you. It might be a spouse or a parent or a sibling who is interested in you and wants to help you out and is willing to contribute money in return for a percent ownership, but they don't really want to participate in the day-to-day operations. They want to let you operate everything, do all the labor. In that case, you should get paid a salary. And if you don't get paid a salary, under the default rules, remember everybody gets taxed according to their gets income according to their percent ownership. So if your silent partner owns 25% of the company, then 25% under the default rules of partnership taxation, they can't be, none of you can be employees, you can't get paid salaries, so everybody gets distributions in proportion to your ownership. But if you're a W-2 employee of your own company, you own only 75% of it, but you do 99% of the work, you can take out a larger income and leave some, just according with an agreement with your partner, of course, you'll have a larger percentage income than your partner would have. They would only participate in distributions that are left over after distributions of profit that's left over after paying your salary. So two great reasons that you should use an LLC as your form of governance, but elect to be taxed as an S-Corp. There are some disadvantages if you decide you want to blow the company up and go public or try to get venture capital. Venture capitalists prefer that the company be a straight corporation and be taxed as a C-Corp. But that's a topic for a different talk. So my final recommendation is, just summarize, form your company as a LLC and elect to be taxed as an S-Corp. There are some other variations, and we can talk about that when you call us up for advice, but that's the bottom line for most cases. Again, it's Michael Mort with Argent Place Law, the law firm for entrepreneurs, because we're looking out for you. Thanks for listening.